There may be some more people joining, but it seems to have the most of the bulk has come in, so we'll get started. Good afternoon. My name is Jennifer Peters. I'm with our Arizona Center for Rural Health, and I welcome you to our Arizona State Office of Rural Health webinar series. Next slide, please. So our webinar series is made possible with the support of our key partners at the Arizona Telemedicine Program and Southwest Telehealth Resource Center. Next slide. And just a few tips and notes before we jump into our presentation today. The audience is muted during the presentation, but you are welcome and encouraged to enter questions into the chat box, which we will definitely leave some time to address at the end of the presentation. There will also be a post-webinar survey that should pop up as you exit the show at the end of the hour, and the recording will be posted on our Center for Rural Health website, as well as the website of the Southwest TRC. And today's presentation is on COVID-19 vaccine mandates, the legal and ethical issues. Next slide. And I am pleased to introduce Jennifer Piat, and I probably should have checked if I'm pronouncing that correctly. Is that correct, Jen?
It's actually Piat.
Piat, thank you so much. Jennifer Piat. Jen is the Deputy Director of the Network for Public Health Law's Western Regional Office, and she also serves as a research scholar with the Center for Public Health Law and Policy at the Sandra Day O'Connor College of Law. Jen earned her JD at the Sandra Day O'Connor College of Law at Arizona State University, and before joining the network and the College of Law, she worked as a law clerk for Vice Chief Justice Ann A. Scott Timmer at the Arizona Supreme Court, and as a pharmacy regulatory attorney at Quarles & Brady's Phoenix office. And we are thrilled to have you, Jen, at such short notice talking about this incredibly timely topic. I'd also like to mention that Leela Barraza is joining us as a panelist and facilitator, and that will help us get to some really good questions throughout the presentation and near the end, since they're questions that are probably much better handled by the lawyers on the call. So with that, I really look forward to this presentation, and I will turn it over to you, Jen. Thank you.
Thanks so much, Jennifer. And good afternoon, everybody. Thanks again for joining us today. As Jennifer said, my name is Jen Piat. I am the Deputy Director of the Western Region Office of the Network for Public Health Law and a research scholar at the Center for Public Health Law and Policy at ASU Sandra Day O'Connor College of Law. And today we're going to be tackling the timely and intricate topic of COVID-19 vaccine legal mandates. So before we really turn to the subject of vaccination mandates, I'd really like to just set the stage with some of the latest data. And this data I pulled yesterday, so from the New York Times tracking numbers. As of August 18th, there were 208.7 million global confirmed COVID-19 cases, 37.1 million of those in the US alone. And over 4.3 million global COVID-19 deaths, with more than 620,000 of those occurring in the US. And this trend, unfortunately, is increasing rather than decreasing, due largely to the highly virulent Delta variant that is circulating across the nation. The average trends in increase in cases in the US over the past 14 days is 52%. And the average increase in deaths in the US over the last 14 days is 87%. Now, on the vaccination front, as of August 17th, about 198.9 million US residents had received at least one dose of the COVID-19 vaccine, and 168.9 million had been fully vaccinated. So that is roughly 60% of the population sitting at least partially vaccinated numbers. The map provides some additional detail for specific states and specific areas. But of course, Delta has thrown a wrench into these increasing vaccination numbers. Some reports have indicated that Delta is so transmissible that it pushes that herd immunity threshold above 70% and more into the 80% range. So vaccine mandates have been discussed as a means to increase vaccination rates since long before even the first COVID-19 vaccinations received EUA authorization in December of 2020. I've saved this particular slide from a previous presentation I gave in March concerning several, and it addresses several news stories emerging regarding vaccine mandates across the country. And what you could see from some of those headlines is that as of March 2021, some employers had actually already started to institute vaccine requirements, Wyoming nursing home, a New York restaurant, and the mandates had also begun to sort of see legal challenges in court, like one of the lawsuits that was filed by a New Mexico corrections officer. Now we've come quite a long way since March. These headlines on this slide are much more current. I pulled them within the past week or so. And they indicate that huge US employers, including large healthcare employers, United Airlines, Tyson Foods, Walmart, Disney, and even tech companies like Google and Facebook have at this point instituted mandates. And this slide doesn't actually even touch on the public sector mandates implemented in several cities and states across the country. And I will get to some of those later. But first, how did we get from December 2020 to March 2021, and then here we are in August? Hopefully today I'll be able to kind of convey that transition and what we saw take place. But in order to do that, we need to start with the basics. So let's go ahead and dive right into the origins of vaccine mandate jurisprudence. And this is coming directly from the United States Supreme Court. So the first case, or the seminal case that we can point to when we're discussing the legality of vaccination mandates in the US, the constitutionality of those mandates, is a case that was issued over 100 years ago. And this is 1905's Jacobson versus Massachusetts. Now in Jacobson, a smallpox outbreak occurred in the city of Cambridge, Massachusetts. And so the city's Board of Health instituted a smallpox vaccination mandate applicable to residents. And residents would either be required to get the smallpox vaccine or pay a $5 fine. And Henning Jacobson, who is the plaintiff on the case, who you can see on the slide before you, he challenged that mandate all the way to the United States Supreme Court. And there the court upheld it. States have what are called police powers, and these are powers to legislate and regulate to protect the general welfare and health of the population. And the court in Jacobson said simply that those police powers do allow states to enact vaccine mandates to protect public health. There are some limitations to this. For example, people with legitimate medical contraindications to vaccines should not be forced to undergo them. But this case established the general power of states to be able to require vaccination for public health purposes. And there's another pretty famous case that I'd also like to discuss just briefly. And this is a case involving a San Antonio requirement that school children complete vaccinations before attending school. And the Supreme Court again affirmed this same concept in the school context. This case is 1922's Zucht versus King. And in this case, the court explained that a state can provide for mandatory vaccination and can then constitutionally also delegate that authority to a locality, to a municipality. So these two cases together really established the foundation that we're building on, that public sector vaccine mandates can be instituted. So this slide just briefly kind of summarizes what we've just discussed. There hasn't actually been a United States Supreme Court case since Jacobson and Zucht, which changes that constitutional interpretation. So state governments can constitutionally require people to be vaccinated in order to protect public health. And the most prominent example we have of this phenomenon of public sector mandates is the one that came up in Zucht. It's school-based vaccine mandates. All states, including the District of Columbia, have statutory and regulatory provisions which require children to complete specific vaccinations in order to attend classes on school campuses or to attend childcare facilities. And the most common of those requirements involve the DTaP, IPV, varicella, and MMR vaccines. So it's also important, though, in this context to be aware of the fact that there are state-specific vaccine mandate exemptions. Each state sets its own requirements, and it also sets its own exemptions. And this results in somewhat of a patchwork of policies from state to state. Now, as you can see on the slide, illustrating non-medical exemptions, 29 states allow for religion-based exemptions. 15 states allow for both religious and philosophical exemptions, and 6 states allow only medical exemptions. So they do not allow either religious or philosophical exemptions to public sector or school vaccine requirements. So we've talked about sort of the foundations for the public sector vaccination mandates, but when it comes to employer-based mandates, the issue is different. And that's because the United States Constitution, first and foremost, protects individual rights against intrusion by state action, by governmental interference. So private employers are not considered state actors, and therefore employer-based mandates can be sort of unbound from these constitutional requirements. And because of this, and also because employment in the United States is almost universally at will, which means that employers can terminate the employment relationship for any reason not expressly prohibited by law, private employers have generally been able to decide for themselves whether to require employee vaccinations. And we've seen this in the past, most commonly arising in the healthcare industry, as healthcare institutions across the country have commonly required vaccination of staff in order to work on site. And that includes, for example, yearly influenza vaccinations. But there are other specific issues that employers do need to be aware of. Specifically, this includes guidance by administrative agencies. So on the slide, I have, the EEOC and OSHA, the Occupational Safety and Health Administration. These agencies have both weighed in on this issue. OSHA ensures that employers are providing a safe workplace, and the EEOC enforces civil rights protections to prevent religious or disability-based discrimination in the workplace. Employers have to be cognizant of these protections, and I will discuss those a bit more in some detail in a moment. But for now, I just want to pause with the notion that private employers acting in compliance with applicable laws have largely been permitted to impose vaccine requirements on employees in the past. But we've been avoiding one key ingredient in our discussion so far, and that does distinguish COVID-19 vaccine mandates from other vaccine mandates. This issue stirred up heavy discussions in late 2020 and throughout the entire first half of 2021. And that ingredient is what's on the slide before you. The vaccines we've been discussing up until now, influenza, DTaP, MMR, they have been fully approved by the FDA. They have full biologics licenses. COVID-19 vaccines do not. They are authorized under a separate emergency use authorization, which is used in emergencies like the current COVID-19 pandemic. So the question is, while mandating vaccines that have been issued full licensure is lawful, what about mandating vaccinations under an EUA? So much of the initial discussion centering on this point involved specific language contained in the Federal Food, Drug, and Cosmetic Act regarding EUA products. And that language is laid out, but specifically the language requires the Secretary of Health and Human Services to establish the conditions necessary to protect public health, including ensuring that individuals are informed of the option to accept or refuse administration of an EUA product, consequences of that refusal, and any available alternatives. And this is the language that really sparked debate over whether the FDCA prevented institution of mandates by requiring individual choice. So before we go on and kind of dissect this language and see what sorts of interpretations we've already seen, I do think it's important to fundamentally distinguish here and now between two different kinds of public health powers, and that might help clarify the issue a bit. So there are compulsory public health powers and there are mandatory public health powers. Vaccine mandates are not forcible injections. A mandatory public health power imposes a condition on participation to incentivize participation. It could include conditioning benefits, rights to access, or fines on that participation. And the best example of this is what we've already talked about in some depth. It's conditioning public school attendance on completion of certain vaccinations. Without the vaccinations or an applicable state law exemption, students are unable to attend public school. Parents still retain the right whether or not to vaccinate, but the privilege of that public school attendance can lawfully be conditioned on the choice. Compulsory public health powers are a different animal. These powers don't allow for individual choice, and they are accomplished by force. So an example might be public health officials going door to door and essentially vaccinating individuals. These kinds of public health powers are very ethically problematic and constitutionally suspect, and they've fallen out of use. So it's important to remember that here we are discussing vaccine mandates. We are not discussing compulsory vaccination. Now let's discuss some of the federal government guidance that emerged early on in the arena of COVID-19 vaccine mandates. First, the CDC has informally addressed the issue by posting some language onto its website addressing COVID-19 vaccination mandates and exemptions. And this information explains that while the FDA does not mandate COVID-19 vaccination, whether a state, local government, or employer may require or mandate it is a matter of state or other applicable law. And there's similar language down below addressing employer vaccine mandates. So this supports the conclusion that mandates are lawful, subject to any contrary state law. We've also seen some useful guidance on this subject out of both OSHA and the EEOC. And so OSHA's guidance pre-COVID-19, the most substantial sort of piece of guidance directly on the point of employer vaccine mandates was a standard interpretation letter issued during the H1N1 swine flu epidemic in 2009. And this addressed an employee's question as to whether or not her employer could require her to get a flu shot. Now, OSHA expressed that it was important that employees be properly informed of the benefits of vaccinations. It explained, though, that while it did not require employees to get vaccinated in order to ensure a safe workplace, that employers were well within their rights to do so. Now, on January 29th, 2021, OSHA released some new guidance during the COVID-19 pandemic, specifically outlining recommendations for employers with respect to COVID-19. And the guidance recommended making COVID-19 vaccines available at no cost to all eligible employees, as well as providing information and training on the benefits and safety of vaccinations. OSHA also recommended against distinguishing between vaccinated and unvaccinated employees, noting that vaccinated employees should still be required to follow certain protective measures like masking and social distancing. But OSHA issued additional guidance specific to healthcare workplaces in June of 2021. And these requirements incentivize but do not require COVID-19 vaccination in those specific healthcare workplaces. Specifically, the guidance requires employers to quote unquote support COVID-19 vaccination by providing reasonable time and paid leave for vaccination and any side effects following that vaccination. So the EEOC's guidance has been a bit more substantial on the direct subject of mandates. But before the full force of the pandemic, EEOC had already agreed that employers could mandate vaccination. So in an updated March 21st, 2020 guidance document, the EEOC explained that employers mandating flu vaccines would need to provide accommodations in order to ensure compliance with the Americans with Disabilities Act, the ADA, and Title VII of the Civil Rights Act. And these provisions are a little bit complicated and can create some additional requirements for the employer. And so because of that, EEOC in its previous guidance did recommend that ADA covered employers consider simply encouraging the flu vaccine rather than requiring it. So I do want to take apart the ADA and the Civil Rights Act to kind of fully flesh out what these protections are and what EEOC means when it says accommodations. So the Civil Rights Act, first and foremost, Title VII, provides that employers on notice of an employee's religious objection to a vaccine mandate must provide a reasonable accommodation, unless that accommodation would result in undue hardship or a more than a minimal cost to the employer. And the ADA in turn provides that individuals with disabilities who pose a direct threat to the health or safety of the unvaccinated have to be offered reasonable accommodations upon request, unless that would result in an undue hardship on the employer. An undue hardship under the ADA is defined differently, and that means significant difficulty or expense. So the bar for undue hardship is actually higher under the ADA than it is under Title VII of the Civil Rights Act, but reasonable accommodations in these scenarios might include offering a telework option, erecting a barrier, temporarily modifying working schedules, or enhancing protective gear. So with that information fully fleshed out, let's move on to the EEOC's updated guidance, specifically addressing COVID-19 vaccine mandates. In a guidance document published on December 16th, 2020, which was updated on May 28th, 2021, the EEOC explained that if an employee can't get vaccinated for COVID-19 because of a disability or a sincerely held religious belief, practice, or observance, and no reasonable accommodation is possible, then it would be lawful to exclude the employee from the workplace. Specifically, and sort of succinctly put, equal opportunity laws enforced by the EEOC do not prevent employers from implementing mandates so long as those employers are compliant with those applicable protections. So this guidance was one of sort of the first indicators that helped to confirm kind of the general analysis that employer COVID-19 vaccine mandates are lawful, subject to, again, state-specific exemptions or other limitations. So let's dive into some of the emerging legal issues that we've seen regarding COVID-19 vaccines. And I want to specifically address here, now that we've shifted into this topic, the arguments about that optional language in the FDCA. So while lawsuits challenging vaccine mandates were being filed and have been filed since early 2021, this is the first case where we actually saw an applicable result. And this is Bridges versus the Methodist Hospital. It's a case decided by a federal district court in Texas. Now, this litigation emerged after Houston's Methodist Hospital implemented a COVID-19 vaccine mandate for its staff, and this resulted in the suspension and subsequent termination of employees who were not compliant. Former employees of the hospital challenged the mandate, arguing that the hospital had one, engaged in wrongful termination, and two, had violated that provision of the Food, Drug, and Cosmetic Act that we already talked about, the sort of optional language. The court dismissed the employee's case, finding that both arguments were wanting. First, the court explained that the wrongful termination argument was not grounded in Texas state law. Texas wrongful termination law only prevents termination on the basis of an employee's refusal to commit a criminal act. And COVID-19 vaccination is not a criminal act. Therefore, termination on this basis would not satisfy Texas law on sort of wrongful termination. The court then confronted the Food, Drug, and Cosmetic Act language head on. And it explained that all that language does is set requirements on the Secretary of the Department of Health and Human Services, what he or she is required to do and the information he or she has to make sure people receive. The language has nothing to do with private employers and does not prohibit private employer mandates. And the court also really sort of leaned in on this, this distinction of compulsory versus mandatory public health powers. It didn't say that in so many words, but it did say that the employees, the former employees of the hospital may have been faced with a difficult choice, but they still had a choice: get vaccinated or face termination. Other arguments, including a claim that the mandate violated federal law protecting human subjects, were also quickly dismissed. The court simply explained that hospital employees were not participants in a trial. The case has been appealed to the Fifth Circuit Court of Appeals. There has not been a subsequent decision as of yet. Now, we've seen a decision with a similar outcome in the university context as well. So this case is Klassen versus the trustees of Indiana University. In this case, Indiana University students challenged the university's vaccine mandates for students as unconstitutional. Specifically, the students argued that the requirement violated their 14th Amendment substantive due process right of bodily autonomy. And they also argued that the mandate violated the First Amendment's protection of the free exercise of religion. Now, the court it wrote a lengthy 100-page opinion sort of detailing how it was going to analyze these arguments. And it determined that no matter what argument it was looking at, only the lowest level of judicial scrutiny, what's called rational basis scrutiny, would apply. And when this kind of scrutiny, when rational basis scrutiny is applied, more often than not, a challenged action gets upheld. And so when talking about the 14th Amendment-based argument, the court explained that you only apply a higher level of scrutiny when the right involved is a fundamental right. And the court sort of reasoned out that there is no fundamental right to avoid vaccination as guaranteed by the Constitution. Now, on the First Amendment argument, rational basis scrutiny, or that low level of scrutiny, is applied when laws are neutral and generally applicable. So to sort of simplify this, it's mostly means that the low level of scrutiny applies when a law doesn't target religious exercise or practice, when it's neutral and applies to everybody. And so the court explained that the vaccine mandate here did not target religious practice. It was neutral and it was generally applicable. So no matter which argument it was looking at, 14th Amendment, First Amendment, only that lowest level of scrutiny would apply. And the court therefore upheld the mandate, finding that the university was constitutionally allowed to require vaccination. Now, on August 2nd, just a few weeks ago, the Seventh Circuit Court of Appeals refused to intervene and block the district court's decision while the appeal was pending. It agreed with the district court that there is no fundamental right to refuse vaccination. And on August 12th, 2021, the Supreme Court of the United States actually rejected a petition to immediately block Indiana University's vaccine mandate. Now, I do want to talk about one other decision that we've seen come out on the side of vaccination, of implementing sort of vaccination requirements. But this decision is in an entirely different context. So this is a private company sort of challenging a limitation. So as a bit of background to get into this case, Florida passed a law during the most recent legislative session, which prevents businesses from requiring documentation of proof of vaccination. So many of you may have sort of read about this idea of so-called vaccine passports, and the Florida law banned use of these. Norwegian cruise lines challenged that law, arguing that it was unconstitutional. And the court in this case actually agreed, and it agreed on very interesting bases. It agreed on First Amendment free speech grounds and on dormant Commerce Clause grounds, which I will talk about both of those in turn to break them down. With respect to the freedom of speech analysis, the court, looked at the restriction and determined that it was a restriction on COVID-19 vaccination documentation. It is singling out this specific kind of documentation and subjecting it to restrictions that aren't applicable to other documents. So it is restricting speech based on the content of that speech. Because of that, it gets subjected to the highest level of constitutional scrutiny, and it failed to pass muster. The Dormant Commerce Clause argument is different. It does not involve individual constitutional rights at all. Rather, the Dormant Commerce Clause is sort of the flip side of a Commerce Clause-based argument. So the Constitution, through the Commerce Clause, actually gives to the federal Congress the power to legislate in areas of interstate commerce. And the Dormant Commerce Clause sort of prevents states from interceding on that power that is given to federal Congress. It prevents states from imposing unjustified burdens on interstate commerce. So the court looked at this sort of argument and reasoned that the law was not justified. It imposed substantial burdens on interstate commerce and therefore could not stand. So these three initial decisions may certainly help shape other litigation that is being filed and that is pending throughout the country, because the reasoning in these decisions may be considered to be persuasive by other courts that are addressing the same issues. Now, seeing these first few decisions may also have helped universities or employers across the United States feel more secure in establishing mandates. But another legal analysis which may have helped in this regard is a July 26, 2021 opinion letter issued by the Department of Justice's Office of Legal Counsel. So in this letter, the OLC Deputy Counsel to the President expressly addressed the question that we've been talking about, whether the language in the FDCA prevents vaccine mandates if the vaccine is under an emergency use authorization. And the OLC specifically concluded that the language in Section 564 specifies only that certain information be provided to potential vaccine recipients and does not prohibit entities from imposing vaccination requirements. So, in recent weeks, vaccine mandates have risen across the country in both the public and the private sectors. The federal government's approach to mandates has evolved across various sectors. So first, on July 26, 2021, which is the same day that OLC opinion letter was issued, the Department of Veterans Affairs announced that it would require 115,000 of its frontline healthcare workers to be vaccinated against COVID within the next 2 months. On July 29th, President Biden announced that all federal employees would be asked to attest to their vaccination status. Unvaccinated employees would face weekly or biweekly testing and screening, a masking requirement, and also potentially prosecution for falsely attesting vaccination status if unvaccinated. And on August 9th, Department of Defense Secretary Lloyd Austin announced that vaccinations would become mandatory for all US military service members by mid-September. Now, public sector interventions have also been implemented at the state level. For example, California has instituted broad requirements for its government and healthcare workers. And on August 11th, Governor Gavin Newsom announced that California teachers and school staff would be required to undergo either COVID-19 vaccination or weekly COVID-19 testing. And it became the first state to institute that kind of a requirement. Now, on the locality side of the equation, on August 3rd, New York City Mayor Bill de Blasio announced that the city would require proof of COVID-19 vaccination as a prerequisite to certain activities, including indoor fitness, dining, and entertainment. And this move is in addition to a number of mandates that were already issued by the city, including requiring city workers and healthcare workers to get vaccinated. And on August 16th, just a few days ago, the city mandated vaccination for visitors and staff to museums and other cultural institutions. In Arizona, mandates have been implemented in the private sector. There have been attempts to institute mandates at the public sector, but I will talk about that in just a second. First, let's focus on the private sector. So Banner Health implemented a COVID-19 vaccine requirement that all of its employees be vaccinated by November 1st. Mayo Clinic announced a similar requirement that all employees be vaccinated or participate in a specific declination process, which would include masking and social distancing, by September 17th. Honor Health announced that all employees would have to get vaccinated by November 1st, and Phoenix Children's Hospital announced that all staff would be required to get vaccinated by October 1st. In addition, the Tucson City Council very recently voted to require proof of at least one dose of the vaccine for city workers by August 24th. But a subsequent executive order issued by Governor Ducey on August 16th stated that any locality implementing a vaccine mandate is in violation of state law. So I'd like to elaborate a bit on this point and reflect back on the recent legislative session. States have considered many different types of vaccine bills in the most recent legislative session. Those in green may help advance vaccination efforts. For example, allowing adolescents to consent to required vaccination introduced in 4 states. But those in orange and red are more restrictive. And as you can see there, 18 states introduced legislation to prohibit all vaccine requirements, and 15 states introduced legislation prohibiting the COVID-19 vaccine specifically. So what has this looked like in Arizona specifically? So Arizona is actually one of those states that has passed restrictions on vaccination efforts. Let's take a look at some of that language now. So first, Arizona's health budget reconciliation bill, which was signed into law by Governor Ducey on June 30th, requires employers to provide reasonable religious accommodations for vaccination. It also prohibits governmental entities from instituting vaccine passport requirements, but it expressly does not prevent an individual from requesting his or her own vaccination records, nor does it prevent healthcare institutions from requiring the institution's employees to be vaccinated. Arizona's higher education budget reconciliation bill expressly prevents COVID-19 requirements by public universities, community colleges, or the Arizona Board of Regents. And this bill was signed into law on June 30th as well. It also prevents requiring masking or mandatory testing if a person chooses not to obtain a COVID vaccine or chooses not to disclose whether they have been vaccinated. Certain exemptions apply, including allowing healthcare institutions to make requirements of students in clinical settings. But the bill then allows testing to be required by public universities only where a significant outbreak occurs in shared student housing which poses a risk to students or staff. Finally, Arizona's K-12 education budget reconciliation bill and the health budget reconciliation bill prevent county, cities, towns, school districts, and charter school district governing boards from requiring face masks on school property, nor can they require masking or vaccination in order to participate in in-person instruction. And the legislature also wrote into law that EUA vaccinations are not required for school attendance. So now, these bills might help sort of illustrate what is somewhat of a sobering fact on the slide before you, and that is that most of the vaccination-related bills enacted in 2021 will limit childhood vaccination efforts, and that's especially for COVID-19. There are substantially more bills in the red than there are in the green, illustrating some state legislatures' current attitudes towards vaccination that will make vaccination efforts much more difficult in those states. That said, these bills, like the one we already discussed in Florida, may be subject to litigation and to limitation in the coming weeks and months. So it's going to be important to watch how that plays out. We have seen some of that litigation right here in Arizona. Phoenix Unified School District implemented a masking requirement, and its requirement was almost immediately challenged as contrary to state law. But a court has so far rejected that challenge because the laws do not actually become effective until September 29th. So there's no actual current requirement in the law to base that challenge off of. Now, one final note that I wanted to make that might sort of prognosticate what we could expect in the future as the legal landscape continues to develop here. I did want to touch back on vaccine mandate exemptions. And specifically, I wanted to address religious exemptions and focus in on what we've seen out of the Supreme Court this past term. So over the course of the pandemic, the Supreme Court has, in a series of orders without substantial elaboration, upheld freedom of religion-based challenges against COVID-19 public health social distancing measures. And the cases on the slide before you actually illustrate what the approach by the court was in May 2020 and what the approach of the court shifted to in November 2020 after the confirmation of Justice Amy Coney Barrett to the court. So after, with Roman Catholic Diocese versus Cuomo sort of starting this trend and then continuing afterwards, the court has blocked enforcement of social distancing measures applied against religious organizations. And the court in these opinions decided that the limitations at issue were not neutral and not generally applicable. So those issues that we spoke about before. And therefore they applied the highest level of judicial scrutiny, striking down the public health measures. And in another decision this term, Fulton versus the City of Philadelphia, the Supreme Court actually cast some doubt on whether it even wants to continue applying that neutral and generally applicable test. So it seems clear from some of these decisions that the Supreme Court has, in essence, elevated religious freedoms and could very well require in the future, in some future case, that all public sector vaccine mandates include religious exemptions in order to be constitutional. Now, I know that was quite a bit of information very quickly, so I would like to turn it over to my colleague, Lila Barraza, who will be moderating the Q&A session, but thank you all so much for your attention. I very much appreciate it.
Thank you, Jen. That was so informative and so helpful. And I know we've already had some questions in the chat box, so I want to just get right to our questions. The first question, will the slides be available? Yes, there will be a recording of the presentation and the slides on the Center for Rural Health webpage. So those will be available there. And here we have first question coming in. or the next question coming in. I just want to make sure I get this important issue correct. This is the question. So the state governor of Florida is not permitted to ban vaccine passports for Norwegian Cruise Line. Is that correct? I'm guessing that therefore no employer or organization in Florida and all states can ban vaccine requirements. Do I have this correct? That is, I'll pass it to Jen for that question.
Sure. So this is interesting. The decision in the Norwegian Cruise Lines case actually granted very, very, very narrow relief. So it granted relief to the plaintiff in the case, Norwegian Cruise Lines, and it essentially said it would be a violation of the First Amendment and the Dormant Commerce Clause to apply this restriction to Norwegian Cruise Lines. So it did not actually apply a broad strokes limitation. It applied it against those plaintiffs. But I also want to say, first of all, that decision could be seen as persuasive in other jurisdictions. So if other jurisdictions or other trial level courts are getting these kinds of questions, they might look at that Norwegian Cruise Lines case and say, I'm convinced by the reasoning of this judge, and I'm going to cite that and come to the same conclusion. They also might not. But I also want to clarify that, that this case is a trial court level case. So it's not binding on any sort of courts below it, like where we would have, you know, this United States Supreme Court decisions be binding everywhere in the nation. This trial court level judgment stands in Florida, but it doesn't bind any other decisions because there are no sort of courts underneath it in that structure.
Great, and I see a comment from the person who put in the question to say thank you. So
sure.
Thank you for the answer. Please, to anyone on the webinar now, please enter your questions into the chat box so we can get those addressed. While we wait for some additional questions to come in, if you wouldn't mind, Jen, because I think this, some of the audience may be working on, well, I just saw a question in, but just quickly, some of the participants on the webinar may be some rural hospitals. So if you wouldn't mind touching again on maybe more of the recent status you've seen in the Houston Methodist case, or what you might see predict based on that case and some of the other challenges to some of the mandates you mentioned from other hospital systems.
Sure, Leela, thanks. So I have not seen yet a Fifth Circuit Court of Appeals decision either affirming or overturning the district court's determination. But I think what we can glean from that case and what we can glean from the Office of the Legal Counsel's advisory letter to addressing sort of these arguments, I think employers may be more comfortable now than they were previously with implementing COVID-19 vaccine mandates, regardless of whether the vaccine is fully licensed, because we have now an interpretation out of a federal court and an interpretation from the Department of Justice, essentially saying that mandates are lawful. That may be limited, though, based on your specific state law. So if your state is one of those states that has passed one of these limitations, then that will be a barrier, or that may be something that arises in a subsequent challenge, in subsequent litigation.
Great, thank you. We just had a slew of questions come in. Next question. I know that you were looking at kind of the weight of opposing bills, the weight opposing bills currently hold. Is there a chance where there could be a change with new information coming in every day?
I think certainly there could be a change. I think we have seen some indicators of potential sort of changes in some states. So, for example, Arkansas was one of these states that passed a law banning mask mandates in public schools, broadly banning mask mandates. And as soon as sort of news started coming in and Delta really hit and hospitals started to get overwhelmed with patients, Arkansas's governor actually called a special session of the legislature to see if they could get that restriction removed, to see if they could to pass a law to change it because of the risks of Delta. And though that didn't end up resulting, what did result was a litigation-based challenge against that law. And the trial court in that case actually struck down the law because it, one of the reasons that it did that was because the law prevented public schools from mandating masks, but did not prevent private schools from doing so. And so it ended up actually being an equal protection violation where it was treating two similar entities differently without substantial justification.
Thank you, Jen. The next question we have is there a difference between requiring vaccination and requiring regular COVID-19 testing? Could the testing be interpreted as too burdensome?
So this again is going to depend on specific state law. And that is because some state legislatures have, or some governors have, implemented restrictions, essentially requiring COVID-19 testing. So there are some states that have banned mask mandates. There are some states that have banned vaccine requirements. There are some states that have banned required testing. So it's really important to sort of take a look at what action took place in your particular state within the legislative session. But yeah, it's an evolving issue currently through litigation, through additional changes.
Thank you. And the next question, how does one prove religious reasons for not taking a vaccine? Can someone just say they refuse for religious reasons?
So Leela, actually would love to have you weigh in on this question because I am not personally very familiar with how that process works expressly in Arizona. But again, I would want to say that this is going to be a state-based issue. I think Leela might have some great info that she could add on this, though.
Yeah, what the precedent that we do have for religious exemptions, at least for school children, is that there's in Arizona just a form that is signed by a parent. In the adult context, we don't really have a standard that I'm aware of for religious exemptions. And that really is also because we don't traditionally have adult vaccination requirements. We tend to have it, mainly just at the childhood school entrance level. And so the school entrance requirements now in Arizona is there is a form and the parent signs it. I can say that other states do, some other states do have stricter requirements where you have to attest to sincerely held religious beliefs. But in Arizona, it's just a form and you sign and you seek the religious exemption. And actually in Arizona, it applies to preschool for religious, and then for upper grades, K through 12, it's a philosophical exemption under our state law.
Thanks, Leela.
Thank you. And let's see, we have a couple minutes left for a few more questions. Has any consideration been made on the approach to people who are vaccinated and then test positive?
I'm not sure exactly how to answer that question. In my review of vaccination policies and the kind of requirements that are being implemented, I don't think I've seen specific language addressing breakthrough cases. I have seen language requiring vaccination or requiring testing, requiring vaccination or imposing suspension and potentially termination. But I have not I could not specifically speak on how some of those entities are addressing breakthrough cases in that whole sort of situation.
The next question I think will help a lot of the viewers. What are some of the sources that you recommend to keep up to date with changes in laws or new information?
So first and foremost, I would say, please reach out to me and also reach out to my colleague on this call, Leila Barraza. We are in the Western Region Office of the Network for Public Health Law. We work closely together on these issues day in and day out, and we answer legal technical assistance questions. So any questions that you might have, you can send directly via email to us, or you can go to the network, the network's website, which I saw was just posted in the chat, and you can submit a question that way if you have a question. Now, we also have certain resources that we have developed that are live on the network's website. So I've developed a resource on sort of employer guidance with respect to all these issues that are coming up in relating to COVID-19 vaccine mandates, and that's available on the network's website. I am also currently tracking publicly available information on COVID-19 vaccination mandate litigation, and that resource is also posted on the network's website. So please head over to the website. We have a ton of resources on vaccination, and also send us questions if you don't find a resource that specifically answers your question, because we'd be happy to assist.
Yes, definitely. And yes, I put the website in the chat, so hopefully people can access the website easily. I think we have time for just maybe one more question. There's a couple questions with a similar theme, and it relates to will future FDA approval change the landscape of vaccine mandates?
It could, and the reason why it could is because of those specific state laws. So a lot is going to depend on what specific restrictions your state has in place. But for example, that one of those sort of provisions in the Arizona law that I showed on the slide prohibits EUA vaccines from being required for school attendance, or saying that they are not required for school attendance. And so if the COVID-19 vaccine, or one of them, is no longer EUA, then that provision would no longer apply. And similar states may have other similar restrictions written into law that only apply to EUA vaccines and don't apply to fully licensed vaccines. So any change in that status could change how those mandates can be implemented in those states.
I know there's a couple questions. I apologize that we won't have time to get to, but please reach out. As Jen mentioned, you can reach out to Jen or to myself. And if you have any questions that you'd still like addressed in the time we have, I apologize, we did run out of time to address all of the questions, but thank you, Jen, for this very informative presentation. I know it has been very helpful to everyone watching, and I appreciate your time, and we're seeing a lot of great info, great job, thank you messages in the chat. So thank you for that, your time and effort.
Thank you so much, Leila. Thank you all for having me. It's been a pleasure, and I look forward to connecting with any one of you. Please do not hesitate to reach my email inbox. It's always open.
And as a reminder, if you go to the Center for Rural Health, the Arizona Center for Rural Health website, shortly there will be a recording and the slides. Thank you very much.